Hello, and welcome to today's installment of the Merchant Acquirers Committee and Venable Payments Law Virtual Bootcamp. This is our fourth day of covering legal and regulatory topics for the payments industry, and today we'll be discussing developments in international payments and specific issues under the U.S., Canadian, UK, and EU regulatory frameworks. Before we get started, I'd like to thank Mac for helping to organize this week-long series of webinars, and to remind everyone that we have our final webinar tomorrow at the same time addressing what's next in payments, which will include a look at some of the newest developments in the payments industry. My name is Evan Minsbury, and I'm a member of Venable's payments practice. I'm joined today by Scott McInnes of Bird & Bird, Jeff Root of Gowling, and my Venable colleague, Ed Wilson. Scott is a partner in the Belgium office of Bird & Bird and will be covering the UK and EU portion of our discussion. Jeff is a partner in the Toronto office of Gowling and will be covering issues under Canadian payments laws. Finally, we have Ed Wilson, a partner in Venable's Payments and Financial Services practice, who covers a broad range of international payments-related matters. So our topic for today is international payments, including the regulatory challenges a payments company may face in expanding its services into the US, Canada, the UK, or the EU. Ed will be kicking things off with an overview of international payments and a discussion of developments in cross-border payments. Then I, Jeff, and Scott will discuss US, Canadian, and UK EU regulatory issues. If we have time at the end of the presentation, we'll cover some Q&A. And finally, you'll be able to earn CLE credits for this session, and we will announce the CLE code word in the middle of the presentation. So with that, I'm going to pass the virtual mic to Ed to go ahead and get us underway. Thanks, Ed.
Thank you, Evan, and welcome everybody. Good to have you here. My job is really to set up these other three gentlemen so that they can talk about what they know. So let me give you a brief introduction. What we're talking about here is not the overview of international payments so much, but the payments within several jurisdictions, US, Canada, EU, and the UK. And let's look at the scope of this to begin with. While we know it's international trade and commerce that continue to drive the growth in cross-border payments, what does this mean? Well, global revenue from payments, this is what the payment processors make, reached about 1.9 trillion US in 2018, a 6% growth over 2017. We're focusing here on retail payments. What do processors make, mainly from retail payments? And I'd like you to listen to a little information about the following countries and see and hear how each country uses the electronic payment systems differently, just in terms of volume. Canada, for example, had 21.1 billion transactions in 2018. 38% of its transactions were done by point of sale. At point of sale were done by debit cards. 58% was done by credit cards. As you can see, this leaves almost no room for cash in the Canadian payment world. And in this regard, Canada has the second largest use of credit and debit cards behind South Korea. 99% of Canadians have debit cards. Now let's compare that to the UK, where in 2019, there were 40 billion transactions having a value of over 83 trillion pounds. Debit cards were used for 42% of this, cash for 23%, and credit cards for just 8.75%. And finally, the EU, with 44 billion transactions in 2018, with a value of 34 trillion euro. Credit cards here were 46%, debit were 23%, leaving cash for the remainder. So you can see that a lot of how we approach these markets depends upon the location. Each one is different, and that's what we're here today to hear about, how different and how they tie together, and how do MAC members get in, properly address the differences and penetrate these markets to help consumers and banks and other traditional players who are facing structural and other challenges utilize the markets. We're seeing a lot more large technology and social media companies come into the payments world, and the clearing and network solution providers are having to come up with new methods. Slide, please. This next slide gives us an overview. Where are the payment providers providing work? What are they doing? Well, for consumers, it's remittances, which have taken a large hit, as we know, as a result of the coronavirus, and P2P wallets. Consumers in business, e-commerce, marketplaces, bill payment, loan repayments, charitable donations, health and education payments. Then on the business side, that's both card processing, but also ACH processing on payroll processors, social benefits payments, dividends and claims, refunds, one-time distributions of various things, and then the normal sorts of payments that go on in business, trade, investment, and intercompany transfers. Slide, please. What we're going to be looking at today are kind of the challenges of this. What's the complexity and cost if you're in one country and you want to move to another? What are the timing and delays of the movement of money and value? And of course, what country and region specific legal and regulatory requirements must be addressed? So let's turn the page and start looking at key developments in cross-border payments. And let's go right from 7 to 8, please. Slide 8 shows us the key developments in cross-border payments. There's some fascinating issues out there, and each jurisdiction treats them a little differently. Real-time settlement, international ACH transactions, and what happens there with things like anti-money laundering controls, global e-commerce, retail and remittance and bill payment, both mainly within borders, how they differ, and then the increase in small and medium business payments that are done electronically, the death of the check, as we say. Those are the things we'll be doing, and with that note, I'll turn it back to Evan to get us off with our first spotlight on our country and region-specific issues.
Thanks, Doug. So now we're going to shift gears here to discuss some country and specific region issues and payments regulations, starting with the U.S. Now, this audience consists probably a good deal of MAC members. Many of you are probably already familiar with many of the issues facing U.S. payments companies, banks, acquirers, processors. So I'm going to move fairly quickly through my slides so that we can make sure and get you all enough time with Scott and with Jeff. So here on this first slide, we've broken out some of the key industry regulatory and law enforcement bodies by issue or area of regulation. These slides will be available after the presentation, so rather than read these lists, I'll allow everybody on the call to peruse them at their leisure, perhaps while they're attempting to fall asleep at night. And instead, I just want to highlight a few nuances of the U.S. system. First, you'll notice there are a lot of names on these different categories. It's not unique to the U.S., but you'll notice that there are a number of regulatory bodies with overlapping responsibilities, some that cover very similar topics, some that cover distinct and separate aspects of those same topics. So just as an example, you'll see both the Federal Trade Commission and the Consumer Financial Protection Bureau have authority over consumer protection laws, with the CFPB having a more narrow sliver of that related to consumer financial services protection. So again, this is not unique to the U.S., but as compared to other countries, I think we may have a greater proliferation of various different regulatory bodies. And along those same lines, you'll see that we've included state banking regulators in the consumer protection and the AML columns, but really they could be in all four of these columns. Again, not necessarily unique to the U.S., but there is a great deal of overlap both on the federal level and in regulation by the states, and a non-bank financial services provider providing payment services in the U.S. can potentially find itself regulated at the federal level and in all 50 different states. And then finally, I wanted to point out, we've included the card brands under certain categories here. Visa, MasterCard, Discover, Amex, and then additionally we could include the National Automated Clearinghouse for ACH transactions. To be clear, those are not government regulatory bodies. But because they set rules for the use of their payments networks, and all the participants are bound by contract to follow those rules, there are situations in which they can function effectively as a de facto regulator over this area in terms of use of cards, processing of cards, acceptance of cards, and then the same with NACHA on the ACH side. Then I'm going to go ahead and go on to this next slide, which this is obviously not an exhaustive list of all the things that a company planning on, let's say, expanding into the U.S. or starting a new payments business in the U.S. might need to think about. But these are some big picture important highlighted issues that we need to cover. So again, I'm not going to spend time on every single one of these, but I'd like to talk about a couple, let's say, more unique U.S. wrinkles. First, like we mentioned on the last slide, state law plays a major role in U.S. payments regulation. And in addition to state-specific consumer protection, privacy, and data security laws, companies that meet the definition of certain types of money services businesses, including check cashers, money transmitters, prepaid value, which may also be called stored value, such as prepaid cards, peer-to-peer wallets. These companies could require a license in 49 states and the District of Columbia. And so, again, not unique to the U.S., but we have a large number of states, and we've had experiences where clients coming from other jurisdictions where a single authorization covering one country or an entire region even are surprised to find that they might need up to 50 different authorizations just in order to cover the U.S. market. And then second, I understand that in other regions, it's possible to contract directly with the card networks. In the U.S., only banking institutions can be members of the Visa, MasterCard, and other card brand networks. What that means is if you are a non-bank entity, you're going to need a sponsor contract with a financial institution, with a sponsor bank, in order for you to be able to gain access to the networks in order to act as a payment processor or a payment facilitator. And what that means then is that you have a contract that would bind you to compliance with all of the card brand rules, but it also means that you will be bound to support the compliance efforts of your sponsor bank. And so even if you are not subject, for example, to the U.S. Bank Secrecy Act and its anti-money laundering requirements directly, your contract with the bank is likely going to require you to have your own anti-money laundering program, and so you will end up needing to meet roughly the same level of compliance, even though you're not directly subject to those laws. So I'm going to stop there, and if there is greater interest in talking more about United States specific legal and regulatory issues, I'm going to cover those during Q&A period. I'm going to pass it to Jeff in a second, but before I do, I want to make sure not to forget to give the CLE code, which is International 2020. So I'll say it again for those furiously scribbling right now. International 2020 is the CLE code. We'll go ahead and stop there, and I'll pass the mic now to Jeff. But if you have additional questions about U.S. regulation, I'm happy to cover those either during the Q&A period or at a later date. So go ahead, take it away, Jeff. Thank you.
Okay, thanks, Evan. Yeah, if you could flip the slide to the first Canada slide. Thank you. So Canada, like the U.S., is a federal system. So we have a federal government, but we also have 10 provinces and 3 territories. And there is no one national payments regulator of any description. We have overlapping provincial and federal jurisdiction. And Canada is a little unusual, and I'll talk about this a bit more. Our payments regulatory regime is very much institution-based as opposed to activity-based, which means you are regulated depending on what kind of entity you are, not what you do. So if you are a bank, you are subject to the Bank Act and all kinds of rules about credit cards. But if you are PayPal and you're not a bank, you are under a very different and much less onerous regulatory regime. That's one issue. The other is historically, the Constitution of Canada gives the federal government the power to regulate banks and banking, and they do that. And the Constitution gives the provinces the right to regulate civil, contracts and sort of general business affairs. And so generally, for a long time, it was assumed that if you were a bank, you followed the federal banking rules. And if you were a provincial financial institution, of which there's lots, usually credit unions and things like that, you cannot be a provincial bank in Canada. You have to be a federal bank. That you would just follow the provincial rules. And we had a Supreme Court case based on a Quebec class action several years ago, which said, no, that's actually wrong. If you are a federal institution, you must also follow the provincial rules in some circumstances. So that is still being sorted out in Canada. That's still not 100% clear what that means to all the financial institutions that are federally regulated. There was another class action recently in the prepaid card space where a prepaid card program manager was sued for it was a program with a federal bank, and they were sued for not following the provincial rules, and the court said, yeah, you have to follow the provincial rules. So that is an ongoing issue here. But I'll take you through the regulators quickly. So again, there's nobody in charge of the whole thing. On the left-hand side, on the consumer protection side, the Financial Consumer Agency of Canada, or the FCAC as we call them, is the federal consumer protection regulator. So the federal banks, there are a lot of rules about cards in Canada, a lot of disclosure requirements, how interest is calculated, grace periods, all kinds of stuff. They are the ones that monitor that. But under that, we have provincial consumer protection agencies. So if you are a provincially regulated financial institution, you would have to worry about these guys. It's just the way Canada works, though, just from a business point of view, is we have roughly only about 30 banks in the entire country, of which 5 are 90% of the banking industry. So really, and they're issuing the vast majority of the credit cards and debit cards in Canada too. So the FCAC regulating that small number of banks is really the main consumer protection body. It's doing 90% of the work. But there is a provincial counterparts for provincially regulated entities. Our privacy law is mostly federal. It's a little weird. Provinces have the opportunity to have their own privacy laws. If they're substantially equivalent to the federal one, then their law can be the governing law. I think only 3 provinces have done that. So most entities, whether they're, and this law applies to everybody, not just financial institutions, most people worry about the federal privacy laws, and so the Privacy Commissioner of Canada or the OPC is the one that oversees that. But there are also provincial privacy commissioners. For data security, we don't have any special data security regulators, but like the U.S., Visa and MasterCard do have their own rules that people have to worry about. But any data security issues would fall under privacy, so it's be the same regulators. On the AML side, the good news in Canada is we are a federal system, and it is a federal, most AML is covered federally by something called FinTrack. So there isn't you don't have to register in every province like you do in the US with every state, which is good. The only exception is Quebec, which it doesn't regulate all of the money laundering. It only regulates money services businesses. And so there's an institution called the AMF that you have to register there. So that what happens, I think, a lot of times when people enter Canada, and it's not just because of money services or AML regulations, but a lot of people leave Quebec to the end. It has a very different legal system. It's a civil code system. The rest of Canada is a common law system. It just has different rules about payments, and I'm not. My partners in Montreal are the ones that deal with those. It's a different world. So. Quite often people come to Canada, they start in different provinces and they do Quebec last when they get their stuff together. And we do have sanctions laws in Canada too. And there's a bunch of them, and there's no real regulator. The RCMP is like a lot of them are sort of criminal. So it's the federal police service, the RCMP, that would come after you if you violated them. In terms of the financial institutions regulations, OSFI, or the Office of the Superintendent of Financial Institutions, is the federal prudential regulator of banks, so the one that makes sure the banks are all financially sound. And then the FCAC, as already mentioned, is the consumer protection one. And then the Bank of Canada has some role in our version of NACHA is called the Canadian Payments Association, or Payments Canada. That's the entity that kind of regulates bank-to-bank payments. And the Bank of Canada is involved in governing them. And then we also have the various provincial FI regulators too, which I already talked about. So we want to go to the next slide, Evan. So I've talked about some of this already, but yeah, the main thing I think if you're in a money services business, the good news is that we have a federal system. It's a one-stop registration. They actually respond fairly quickly. We did have some gaps in the law about, there was a loophole actually allowing you to be a foreign money service business without registering, which has now been closed. So I think most people probably find our anti-money laundering laws not too weird. But the issue I think is the overlapping jurisdiction is still a problem with federal and provincial. It's not on AML, but it's on other things. It's just a little unclear which laws apply, especially if you're federally regulated. And that's something that the courts are going to slowly work it out. We also have, interestingly, I guess just to point out who gets regulated. So in Canada, like the US, you have to be a financial institution to issue or to be a member of Visa or MasterCard, at least for now. And so you could create a federal financial institution or you could create a provincial one. Most are federal. And so there is a lot of regulation about financial institutions, of course, as there is everywhere. But if you're in the acquiring and acceptance side of the business, there is virtually you don't have to be an FI. You need some sort of relationship to get into the Visa or MasterCard system. Of course, you need a relationship with an FI. But you don't have to be an FI. And the level of regulations that you face are very minimal, except for one thing that I'll talk about in a sec. We have this code of conduct. And then the other thing the federal government has done is create something called the Payment Card Network Act that allows them to regulate Visa and MasterCard and Amex if they want to. So it's a strange statute. It basically says we have the power to regulate, and the actual rules will be set on these regulations, and the regulations don't exist right now. So basically, it's sort of a sword hanging over Visa and MasterCard. This was done about 10 years ago when there was some tension in the industry about interchange and whatnot. So in theory, they could create regulations and regulate the payment networks. In reality, there's also a constitutional question of whether that actually works, because those networks are not federal financial institutions, so they would say you don't have the power to regulate it. So nothing's happened. There's sort of this hanging out there. But the thing I did want to talk about for a second is this code of conduct. So we had in Canada, sort of when Visa and MasterCard went public, whenever that was, 2007, 2008, before that, in Canada, you had to pick Visa or MasterCard. You could not issue both. When they went public, those rules changed, and you could issue both. So the networks started to compete with each other, and we saw interchange rates rising, and we saw merchants getting unhappy at interchange rates rising. So we had a whole bunch of stuff happening, new regulations coming in. The one thing I think, as Ed pointed out, how we have a very high use of credit cards in Canada, one reason we do is we have very high interchange, which means we have very good rewards programs, and people love these rewards programs. So we have politicians that, while they get pressure from merchants to do something about interchange, they don't really want to cut interchange to pieces because the rewards programs will disappear. So what we've ended up with is a bunch of compromises in Canada. We have the payment networks have voluntarily agreed to lower interchange for 5 years, so that it averages out to about 1.4%, and I think it's about 1.5% now. So that's happening, and then we have this code of conduct, which is voluntary, or I put voluntary in air quotes, because the industry sort of came up with it in consultation with the federal government, but it really, you have no choice but to comply with it if you're in the payments industry. And what's unique about it is it really touches upon acquiring quite specifically, with very specific rules about acquirers, which before this did not exist in Canada. So acquirers have to have, like I know in the US you have these Schumer boxes, and we have the boxes too that disclose things about cards. You have to have those for your acquiring contracts too. So you have to have in the front of the contract all the fees that the merchant might pay. You have to have a disclosure of certain contractual requirements. You're not allowed to raise the fees during the term of your acquiring agreement. If you do, the merchant can exit the contract. And if interchange is lowered and you do not pass it on, the lowering, they can exit the contract for free. So these are, I think, unusual business practices rules. We also have rules about the networks in this code of conduct. So the networks, you know, the honor all cards rule, which you see all over the world, we do not have that in Canada for credit and debit. If you take Visa credit, you cannot be forced to take Visa debit. Merchants also have to be allowed to provide discounts for cash. The networks, and the other weird thing we have in Canada is a national debit card network called Interac, which is, merchants love it because it is dirt cheap. There's no interchange. It's just a very low per transactions fee. And because of that, Visa and MasterCard wanted to bring in Visa and MasterCard debit 10 years ago, and there was a lot of pushback. So this code of conduct really limits how Visa and MasterCard debit can work in Canada. And essentially, they can only work as part of what are called co-badge cards. So like your bank will issue an ATM card that will work at the POS on Interac, but it's not allowed to work at the POS on Visa and MasterCard. So domestic POS transactions in Canada have to be Interac for debit, but they can work internationally and they can work online for Visa or MasterCard. So they're a hybrid type of card. And then now they have become quite popular, and I think people finally understand them, but it took a while for that to get going. And because of that, there's rules, like the cards have to be equally, all the branding has to be same to protect Interac and whatnot. The other thing is, you know, contactless payments is big in Canada, but you cannot force a merchant to take it. Basically, Visa and MasterCard, anytime they roll out any kind of new product, the merchants have to agree to accept it. They cannot be forced to take a new Visa or MasterCard products. So, and there's a couple rules in this code of conduct about issuers, but like that I think is quite unusual for Canada to have such specific rules. And while they are not the law in the sense that they're part of the Visa and MasterCard rules, the FCAC, the Federal Consumer Protection Regulator, is watching for violations, and essentially Visa and MasterCard will fine you if you're offside, and Visa and MasterCard have to report on that. So I did want to spend a bit of time on that because I think that's kind of unusual. The only other thing I guess I wanted to say is just on the back to the slide, the second to last bullet, new federal regulatory framework. So as I mentioned before, we have a weird system where you're regulated by who you are, not what you do. There is a movement to change that. There is a proposal out in a discussion paper to create a sort of regulatory framework for retail payments, no matter who you are. So you would be governed by activity-based as opposed to entity-based, and so that's in the works. But it would catch people like PayPal, people, digital wallet providers, anybody that has an account that lets money move from one place to the other or holds money on behalf of people would be regulated. What those regulations looks like, we do not know, and you know. We're supposed to be some movement here, but COVID has put it on hold. But that's something I think later this year we may see something moving on that. So I think that's all I wanted to say for now, and I'll turn it over to Scott.
Thank you very much. Okay, so talking now a little bit about the EU, including the UK, although as you may know, the UK has got essentially 1 foot left in the EU and 1 foot out already. So essentially in the EU, and I'll try not to spend too much time, by the way, on this slide, but a bit more time maybe on the next slides, where I'll talk a little bit about the substance and the latest, essentially, regulatory developments that are happening in the EU. But essentially, at the EU level, you can sort of assume that, broadly speaking, consumer protection, data protection, data security, AML, essentially regulated at EU level. So you've got either what we call EU regulations or EU directives that sort of regulates consumer protection. That essentially regulates, data protection. I'm sure everybody on this call has heard about the infamous GDPR that now regulates data protection in Europe. For data security or cyber security, we've got something called the NIS directive, which is the Network Information Services Directive, or the Cyber Security Directive. Again, that's EU legislation implemented within the laws of national EU member states. Same thing for AML. We just had a deadline earlier this year, January, to implement the 5th EU AML directive. So all that legislation is EU law, if you like, but the enforcement takes place at the national level. So consumer protection legislation, that's EU law implemented within the laws of the EU member states, but it's enforced by the national, the national consumer protection agencies. GDPR, same thing. GDPR is one regulation for the whole of Europe. but it's enforced at the national level by the data protection authorities, or the DPAs, as it's typically referred to. Same thing for the cybersecurity directive. It's enforced by the data protection authorities, so much like in Canada, apparently. It's the same authorities that enforce both data protection and cybersecurity. AML, same thing. It's the national financial services authorities that enforce AML, although it's EU legislations. When it comes to FS regulations, and in particular payments regulations, same trend. It's essentially EU legislation. So in Europe, we've got the EU Interchange Fee Regulation that caps interchange fees and does a bunch of other things. That's EU law enforced by the national FS regulatory bodies in the different EU member states. We've got payment services legislation. We had PSD1. Since 2015, we've got PSD2, so the EU Payment Services Directive 2. Again, EU legislation, but that is enforced by the national competent authorities. The UK is the only country so far that has a dedicated payments regulator, a regulator that only looks at payments. And that regulator is called the PSR. It's the Payment Services Regulator. And its mission is to enhance competition in the payment space and to enhance essentially better services for the users, typically merchants and consumers. I also mentioned on this slide three, if you like, pan-European or EU bodies, namely the European Central Bank, based in Germany, the European Banking Authority, formerly based in London, now based in Paris, and the European Commission, based in Brussels. They're not, as such, enforcers of FS regulations and payments regulations in particular, but they play a key role because they provide a lot of guidance on how the national regulators in different EU member states should be interpreting the EU law and how they are expected to enforce EU legislation. So that's why I mentioned them on this slide. That's probably what I wanted to say, I think, on the bodies. So maybe the next slide, Evan. That's on the substance. So I picked a few topics because there are a lot of things currently going on in Europe in terms of payments. There are new regulations, a lot of things going on. So I tried to pick a few here. So I've got 1, 2, 3, 4, 5. The first one is essentially, it's a theme that we've got in Europe at the moment. And that theme is essentially sovereignty. There is a strong push by the European Commission, the European Banking Authority, the European Central Bank in Frankfurt, for Europe to be more independent from non-European payment methods, non-European payment schemes, and in particular non-European card schemes. Think MasterCard and Visa in particular, but think Alipay, think WeChat, and the Chinese schemes. It's a big theme, and you can see that theme essentially being pushed across different, a few different avenues. You've got PSD2 on the one hand, and one of the big topics under PSD2 is the so-called open banking provision. Open banking essentially means that European banks are forced to open up the infrastructure so that people can have access to it. And there are essentially two flavors of open banking in Europe. We've got one, banks need to give access to the bank accounts so that third parties, typically fintechs, but potentially other banks, can have access to the data to do essentially data aggregation. That's something that is called Account Information Services, AIS, and therefore account information service providers. So I can give access, so let's assume that I've got bank accounts at 3 different banks. I can give access to an AIS provider, an account information service provider, and he has the legal right to access my bank accounts of those 3 banks. My banks have to give him access to my bank accounts so that he can aggregate the data, for example, in an app that I can have on my phone or on my tablet to see all my data consolidated in one place. And the second flavor of open banking we've got in Europe is payment initiation service and payment initiation service providers, PISPs. And that's meant to be direct competition versus things like MasterCard and Visa and cards in general. The theme there is very clear. It's absolutely transparent if you look at the recitals of PSD2. Essentially, it's saying, look, we've got too much card transactions here. We need more competition. We need more alternative means of payments versus cards. In particular, we want more bank account to bank account payments, what we typically call CTs, so credit transfers in Europe, or direct debits, DDs. We want more of that, and we want less cards. And therefore, what we want is for those PISPs, the payment initiators, to have a legal right to get access to the bank account so that when Scott, for example, goes on a website and he doesn't want to click on the MasterCard or Visa logo, he can click on the logo of a PISP, gives his consent, that PISP accesses the bank account and pushes a credit transfer from Scott's bank account to the bank account of the merchant. That's one transaction less for MasterCard Visa. That's a transaction that doesn't have an interchange fee. That's a transaction that doesn't have scheme fees. That's what we want in Europe. So that's one example of how we want more sovereignty, if you like, from essentially non-European means of payments. Another very clear example is a push for the creation of what used to be called PEPSI and is now called EPI, which is the European Payments Initiative. That's essentially the European Central Bank and the European Commission in particular telling a few large European banks, you're going to build me a European Visa, or you're going to build me a European MasterCard. I want that equivalent, but I want it to be European. I want Europe to be less dependent on MasterCard or Visa or Alipay and WeChat and the China Union Pay. So very clearly EU sovereignty here, the attempt of building a European scheme. Not clear whether that scheme is going to be based on card transactions or on credit transfers or both. I think it's pretty clear there's a preference for credit transfers, in particular for what we call instant credit transfers, or SCT Inst, as we call it here, so SEPA credit transfers, instantaneous. That's the preference. The banks are looking into it at the moment, see how they could build that, see if there's a business case to actually build that. And we expect in a few months to see the conclusion of that work that the banks are doing to potentially build that essentially European competitor to MasterCard or Visa. And the third example, if you like, of that sovereignty theme that we have in Europe at the moment is a report that was just published by the French Ministry of Economy, essentially saying, well, why don't we force all the transactions or all the data related to transactions to stay on European soil, to be localized in Europe? Why is it the case that when I use a MasterCard card, a Visa card in France, that data has to go through processing centers, typically in the US, and therefore the data has to leave the EU continent? Why don't we force that data to stay within Europe? For example, why don't we take the opportunity of the future revision of the EU Interchange Fee Regulation or the revision of the GDPR in a couple of years, for example, to force that data remains on European soil? So they refer to that as a data localization requirement. So those are three examples, if you like, of that theme that we have in Europe, which essentially we need to be more independent from essentially the rest of the world when it comes to payments in Europe. The second interesting thing that is happening in Europe is, again, something under PSD2 that is referred to as strong customer authentication. That is basically the security of payments. It's essentially a requirement that every time a payment takes place, the payer, if it's a card, the cardholder, needs to be authenticated by its payment service provider, for example, its bank. So if you've got a MasterCard card, think of something like you have to do MasterCard secure code every time you use your card. Or if you've got a Visa card, you need to do verified by Visa every time you use your card. So for example, every time you're going to have to enter a PIN, enter a password, your face will have to be recognized by your phone, you'll have to apply your fingerprints on your phone so as to be authenticated, or your card issuer will send you a one-time password in an SMS that you would have to input into your browser, for example, to authenticate yourself. The idea there is to say, look, there's too much fraud for payments. In particular, there's too much fraud online, and there's too much fraud for card transactions online. Thus, this mandate that went live in September of last year, that in principle, every time a transaction takes place, we want strong customer authentication or two-factor authentication. So we want that. So in a physical shop, that means we want, in practice in Europe, we want chip and PIN every time you make a transaction. And if you go online, we want you to do essentially MasterCard secure code or verified by Visa every time you buy. This has big implications. A lot of people actually hate doing, for example, SC or two-factor authentication online because it's got a huge potential to basically kill conversions. A lot of merchants hate it because very often the consumer won't remember what his PIN is or his password is, won't be able to authenticate, and that's a lost transaction for the merchant, and therefore that's lost revenue. Obviously, not good for the consumer if he's not able to buy online, not good for the card issuer, who will have one transaction less and therefore will lose his interchange. Bad news for the acquirer, who won't make his profits on that transaction, and bad news for the scheme. So it's very disruptive. And it's been overly regulated, I would argue, in Europe, because we've got a clear principle, but we've got a lot of exceptions or exemptions, as they're called. A bunch of scenarios where you're exempted. You don't have to do an SCA. For example, you do a contactless transaction in the shop below 50 euros, you can be exempted. You don't have to enter your PIN. But there are cumulative factors. If I've already done 5 transactions without a PIN, I will have to enter my PIN. Or if I've already done a few transactions that add up to 150 euros since my last PIN entry, I will have to type in my PIN. For online, there are a bunch of exemptions as well for low-value transactions below 30 euros, for transactions that are deemed to be low risk, et cetera, et cetera. Hugely complicated area from a technical point of view. So complicated that the industry is late actually complying with the SCA requirements for online transaction. The industry has been granted an extension of the deadline, which was September last year, and that extension is until the 31st of December of this year. Now, the industry is lobbying really hard to get an extension due to the COVID crisis, but it looks like the EBA and the European Commission are not minded to grant an extension to the industry, and therefore the entire industry is working that they're not going to be able to comply with the 31st of December deadline this year due to a lot of people essentially working from home and not being able to make this thing happen. And the EBA and the EC at the moment are saying, look, if you don't comply with this by the end of the year, we're going to be handing over fines. So big topic from a technical point of view, which is raising a lot of questions. Dynamic currency conversion. So we've got an existing EU regulation that has been adapted now, which is a bit of background note on the line. I don't know if you got that too. Essentially new requirements for currency conversion, in particular on the merchant side. So new transparency requirements that are being applied to dynamic currency conversion. So new requirements for the acquirers and the DCC providers, as we call them. So companies like Fexco and Monex that actually help merchants and acquirers provide DCC at the point of sale. Long story short, it's more transparency. So essentially, I'm a consumer, I've got a card in euros, for example, I go to Denmark, which is a country that has a different currency from the euro. They've got Danish kroner there. If a merchant offers DCC, I would have to be displayed both prices, the price in the local currency, in DKK, so in Danish kroners, but also in euros, so that I can make an informed choice as to whether or not I want to pay in the local currency or not. The exchange rate will have to be displayed to me, not in any way. There's a specific way to display the exchange rate. It's versus the ECB rate, so the European Central Bank rate. So the merchant will have to tell me, look, on this transaction, it's 100 Danish kroner. I applied this exchange rate, which is ECB plus 2.5%. That amounts to X in euros. Do you think it's a good deal or not? Do you want this or not? Or do you want your card issuer and the card scheme to do that currency conversion later on? Your choice. Same thing at ATMs. So I would have to be given a choice at the ATM and transparency at the ATM whether I want to make my ATM withdrawals and make that transaction in Danish kroners, in my example, or in euros. So more transparency requirements. Technically, they went live in April of this year. But due to COVID on this one, the European Commission has essentially told the national regulators, we encourage you to basically give some flexibility to the acquirers and DC providers here, and actually to provide for flexible enforcement of these new requirements due to the COVID crisis. Again, something that the EC and the EBA are not willing to do apparently on strong customer authentication. Interchange fee regulation, so we've got that in Europe. So interchange fees have been regulated now since the end of 2015, much lower levels than the levels you've got in Canada. A debit card in Europe is regulated at 20 basis points, so 0.2%. And a credit card is regulated at 0.3%, 30 basis points. So arguably very low levels of interchange that we've got now in Europe. That regulation did a couple of things that are similar to some of the themes that I heard actually in Canada. Like, for example, in relation to co-badge cards, it basically gave the right to any consumer to go to his bank and say, I don't want you to issue me a plain vanilla MasterCard card or Visa card. If this country has a domestic scheme like NTRAC, in Canada, and we do have a few EU countries that have a domestic scheme, Carte Bancaire in France is an example, Bank Contact in Belgium is another, Dencourt in Denmark is another example. You've got a legal right to go to your bank and say, I want you to issue me a co-badge card, a card with that local domestic scheme brand on it, and the international brand, i.e. MasterCard Visa, to essentially allow the card to travel and to be used in another country around the world. The key question has always been, well, who gets to decide which of the two brands is used at the point of sale? And that has been regulated too in the IFR. It's the merchant, first of all, who decides. So the merchant can essentially pre-program its terminals to say, by default, I'll pick the domestic scheme brand or I'll pick the international brand. In practice, 99% of the time, merchants pick the domestic scheme brand because, like NTRAC in Canada, it's typically cheaper. Not necessarily in terms of interchange, because interchange tend to be broadly the same, but in terms of the scheme fees that are paid by the acquirer for the scheme. But the consumer, in theory, has a right to actually override that. So in theory, as a consumer, you can walk into the shop, and if the merchant takes the domestic scheme brand on your card, you can override that by doing something on the terminal, which nobody wants to do in terms of COVID, of course. Everybody's trying to avoid touching the keypad. But in theory, you've got a right to say, well, no, I really want to use, the Visa brand on my card or the MasterCard brand on my card. So that EU interchange fee regulation is up for renewal this year, in theory. The process should be kicked off later this month. We don't know what Europe is going to do on this one. There's a report that has been commissioned by the European Commission on the IFR to try and assess the impact of the IFR on the market, i.e. what has been the impact for the issuer, how much interchange fee revenue have they lost, what's been the impact for the acquirers, i.e. how much of that interchange fee reduction did the acquirers actually pass on to merchants, how much reduction of the merchant service charge that the merchants received did they pass on to consumers, who shop, and what have the card schemes done? Essentially, what we've seen in that report, which is about 200 pages long, is that issuers have lost roughly $4 billion a year in terms of interchange fee revenue. Card schemes have increased the scheme fees they charge to acquirers by roughly 550 million, if my memory serves. So they first increased the scheme fees and took that essentially for them, if you like. The acquirers have passed on roughly 50% of the interchange fee reduction to merchants. So merchants have ended up essentially receiving a reduction of interchange of somewhere around 1.5 billion per year out of a total interchange fee reduction of 4 billion. That's essentially what we've seen happening here. And it's not clear yet what the EU is going to do with that IFR, i.e. is it going to actually propose to revise it now, or is it going to essentially kick it down the road and only revise it maybe in a couple of years' time? It's actually linked to that EPI project that I mentioned before. The banks who are working on the EPI project at the moment are saying, look, we're happy to build this European Visa or this European MasterCard if you want us to, but we need a business case. If you reduce the interchange fees, then there is no business case and we're not going to build it. So there's actually a link here between the creation of EPI and the creation and the potential revision of the IFR. And there's also a link with the PSD2 open banking provisions, the so-called PISPs that I mentioned. You remember, I go on a website, don't click on the Visa, MasterCard logo, click on the logo of the PISP, he pushes the funds from my bank account to the bank account of the merchants. If you further reduce down the cost of cards by further reducing the level of interchange, who's going to use those PISP services? Would merchants be interested in getting connected more to those PISPs as opposed to the MasterCard and Visas they've been using for years that typically works, that typically have a protection against chargebacks? So the further you reduce the interchange fees, the less you create an incentive for merchants to be interested in those PISPs open banking services. So there's a bit of a dilemma there that the EU will have to sort out. My personal guess is they're not going to revise the IFR this year. They will kick it down the road, as I said, for probably 2 to 3 years at least. That's a personal guess. And last point, which is UK specific, but in a way it is connected to the IFR too. There is a specific actually investigation, but they don't call it investigation, they call it a market review, that the UK regulator, the PSR, is doing into the acquiring market. Essentially, it was triggered when the PSR looked at how much of that interchange fee regulation, that interchange fee reduction that resulted from the IFR was actually passed on by UK acquirers to UK merchants. And they essentially realized that the pass-through ratio was, in their view, potentially too small. Either there was too much concentration, essentially for large acquirers, if you like, in the UK, and that the market was so concentrated that they had a possibility not to pass on a sufficiently large proportion of the interchange fee reduction to merchants. And that triggered that market review that the PSI is now doing, looking at the competitiveness of the acquiring market in the UK. Is it competitive enough? Who has benefited from the interchange fee reductions? Guess what? The large merchants did typically benefit. So I think airlines and supermarkets, typically because they were on interchange fee plus contracts with their acquirers. But SMEs have not really benefited from the reduction of interchange. Actually, in a lot of cases, merchants pay more now than they did before to accept cards, essentially to cross-subsidize the large reduction of the MSC that large merchants have benefited from. So the UK regulator is looking into that, and we expect a report in the next couple of months now. It should have been out already, but due to COVID, it's delayed. But in the next couple of months, we expect a report from the PSR, and the outcome could be either more regulation or competition law enforcement, if they identify that there's a competition law or an antitrust, if you like, issue here, or nothing if they come to the view, that this is all perfect and, we don't need to touch it, which sounds unlikely. It's not clear what the remedy is going to be, though, because if you've got 4 large acquirers in the UK, how do you force the entry of a fifth large acquirer to compete with these guys? Are you going to force one of the acquirers to sell a chunk of its business so as to form a brand new acquirer in the UK, or force all 4 of them to sell a chunk of the acquiring business to build a 5th new large acquirer in the UK? Very difficult to imagine what the PSI is going to do here, but you know, they're certainly looking at it. And those were, I think, the themes that I wanted to cover. I've probably been a little bit too long now looking at the time. But.
Thanks, everybody. Got a couple minutes left now for questions. And we've had one here since earlier in the presentation. And the question is, as cross-border payments and fraud increase, enforcing regulations across countries will become essential. Do you see, and I'm assuming this is essentially for everyone, do you see geolocation playing a vital role for AML KYC regulation? And feel free, anyone who wants to chime in. Scott, Ed, Jeff.
Sorry, so meaning, you know, really knowing actually where the money is coming from, like that's what geolocation you mean by that? I assume?
Yes, I'm assuming this would refer to a tool or a resource to determine where in the world the person is as part of the KYC process.
Yeah. Interesting. I have not heard anyone talk about that in Canada, to be honest. We've had a number of, to be honest, in Canada, a lot of our AML is very old school. We have a very high rate of immigration here. We have a lot of people come here with a lot of money, buy houses, and a lot of AML is happening in sort of old school, non-fancy, non-electronic means. So I really haven't seen anyone talking about that, or heard anyone talking about that.
No, same in Europe. I haven't heard about it now.
It has been discussed in the U.S., and it comes up in kind of 2 ways. One is the fact of where someone is does not necessarily have anything to do with where that person is actually starting the transaction.
Right.
I could be, for example, I could be in the UK, but starting a transaction in the US to end up in Canada. So it's almost, in part, it's a false idea of what does it really do to help you. It may be something. The flip side of that in the US has been the pushback against being able to track someone with geolocation. That is a major issue in the U.S. On just personal privacy issues, and I'm sure will come up in other places as well as we watch what goes on, particularly in some countries where there's a lot of geolocation tracking going on.
Yeah.
The only 2 instances where geolocation has come up to the surface recently is one, we've got an EU regulation on geoblocking now in Europe that has been live for a couple of years already, and there's a link to payments, by the way, which is basically that if I want to buy goods or services, you know, on the website in Czech Republic, let's say, that Czech website is not allowed not to sell to me based on the fact that it identifies, for example, that my card was issued in the UK or in Belgium. And that's the link with geolocation. So you can't reject just on the basis of card credentials and say, look, I don't take cards that are issued in the UK because there's too much fraud on those cards, for example. That's one instance. The second one is on strong customer authentication. So as I said, in principle, every transaction, in particular, every online transaction needs to be authenticated by 2-factor authentication or strong authentication. But if the transaction is considered to be low risk, and subject to some conditions, the basis points of fraud that the issuer, the acquirer has across all its transactions, etc., which are very, very low levels, by the way, so it's quite difficult to achieve. But if your basis points are below certain thresholds, and you do a live, so real-time analysis of that particular transaction, and you come to the view that it's low risk, then you can say, on that transaction, I'm not doing a strong customer authentication because it's low risk. And one of the things you need to look at is the geolocation of the buyer, if you have access to that data.
The only other thing I'd add is that for purposes of U.S. BSA KYC, there are particular data points that need to be verified. The overall requirement is that you have a reasonable belief you know the true identity of your customer. you can verify the data provided to you by documentary means or sort of an open-ended, non-documentary methods, which many BSA-regulated entities use different identity verification tools as non-documentary methods. So in other words, they're not checking a passport; they are putting the data points through a process that will give guidance on whether it's likely or not likely that this represents the real person. I could imagine using geolocation as one of a set of tools as part of your KYC process, but I don't see it necessarily being a requirement under any of those laws or guidance, at least not in the near future. We'll see. So we've got about 2 minutes left. Ed, did you have an additional question that you wanted to ask?
I guess I'd like to ask a kind of a two-part question, part to Scott, part to Jeffrey. To Scott, at what point does the sovereignty end? Is it just EU? Does it break down further into countries within the EU saying, well, that's a good idea. We would like to find a way to either capture data, capture information, capture revenue by further, with the result of some balkanization that the EU was formed to end. And I would turn around and ask Jeffrey kind of the same question, that there's always been some Canadian content rules that some U.S. folks have learned to be careful of over time. And do you see any of the same sovereignty drive in Canada that Scott is describing in the EU?
Yes, so the proposal at the moment from the French is to have indeed a data localization requirement at the EU level. So the data should stay on EU soil. It doesn't have to stay in the same EU member state, but it has to stay within the EU. That's the idea at the moment. And it's being pushed by the French, but the French are pushing for amendments to EU legislation, namely the EU Interchange Fee Regulation and the GDPR potentially, in order to make that happen.
Yeah. In Canada, Ed, I have not seen in payments so much of a sovereignty movement. We have a very good banking system, and that is very well protected, right? Like, you cannot, American or foreign banks have a very limited ability to kind of compete in Canada. So just in banking, I think we have a big firewall put up, but in payments, maybe because we have the banking firewall, we're not so concerned about it. So we have no problem with Visa and MasterCard. We did protect our national debit scheme, but I think that was more based on economics and merchant desire for a cheaper alternative than national pride so much. So yeah, so I mean so I think I don't see the same movement here to the same degree as Europe.
It's something that we've actually seen in a few European countries in the past, i.e. when a few, because typically the domestic schemes in the countries that have such domestic debit card scheme, because typically debit, those schemes are typically owned by the banks, and some of the national schemes over the years have said, well, we're going to decommission our scheme because it's outdated, there's no innovation in it, it's loss-making, it costs a fortune, so we would like to essentially pull the plug on that domestic scheme, and we replace all the cards by either Visa or MasterCard. This has happened in the Netherlands. They had one called PIN, decommissioned all the cards. All the cards went to Maestro. The guys in Ireland had one called Laser, decommissioned, all the cards were Visa. But there's been, in a few member states like Belgium, there's been massive pushback, in particular by the merchants saying, but are you out of your mind? You're going to decommission something that works. It may be loss-making for the banks, but frankly, who cares? We as merchants absolutely love it. It's cheap, it works, it's efficient, we get paid quickly. If you decommission it, you open up the doors to MasterCard and Visa, and those guys are going to be so much more expensive in terms of interchange and scheme fees. Don't do that. And the banks had to basically cancel the plan and kept bank contact, this local scheme here.
Okay. Thank you, gentlemen.
Okay. I think that about wraps up our session. Before we part ways, I'm just going to say the CLE code again is International 2020. And I want to thank you all for joining us today. And please remember to tune in tomorrow at 1 p.m. for the final segment in the Mac Venable Payments Virtual Bootcamp covering what's next in payments. Thank you, everyone.